docket. That is case number 104388, Santiago Sola Morales versus State of Kansas.
Good morning. May it please the court. Michael Whalen on behalf of the appellant Santiago Sola Morales. And with the court's permission, I would ask to reserve 5 minutes for rebuttal.
5 minutes is granted.
Thank you, Your Honor. There's kind of big picture and a couple of little pictures to look at today. The big picture is really about what type of standards need to be imposed in the assessment of inmate 1560-1507 petitions. And what I think the courts are getting away from or not recognizing is that the documents that are provided by this court's order for submission on a 60-1507 petition says nothing about prejudice, proving prejudice. And this is similar to the argument I made last year in the Von Tress case, in that we have very limited resources that are given to these individuals. And Supreme Court Rule 183E states that a petition is sufficient if it is substantially in compliance with the forms produced by the Judicial Commission. Subsection F states that if there is an issue, ostensibly, that unless the motion to vacate, set aside, or correct a sentence and files and records of the case in the sentencing court conclusively show that the movement is entitled to no relief, the court must grant a prompt hearing and notify the county or district attorney. So if there is an issue that is not resolved by a review of the record in the case, then a hearing is to be granted by this court's order. Now, the standard that was utilized by the Court of Appeals in assessing this case was basically, 1, you have to show ineffective assistance of counsel. 2, you have to show that there is prejudice. And this is all within the pleadings. But we're dealing with a form that is filled out by uneducated, many mentally ill individuals who answer the questions that are put to them. Section 10 of the 1507 petition says, what are your evidentiary issues? Then what witnesses do you have to support them? And ostensibly, that's all that's required. But the courts have created a greater requirement on these individuals than they do for any other civil litigant. Civil pleadings in Kansas are notice pleadings. You don't have to prove your answers. You don't have to submit all of the evidence. You don't have to have evidence in your petition that shows that you will win the case. But that's the application and how the law is being applied at the very basic level in these cases, where we have greater limitations and in fact, specific forms that must be filled out.
The difference, I'm wondering if there isn't a distinction between form and substance here, though. I mean, you said that the rule states that it is sufficient if it complies or materially complies with the form, as opposed to meritorious under the law. And we do hold pro se litigants to the same legal standards in terms of proving the merits of their case, don't we?
We do, but
isn't that where your
in a
problem is?
civil pleading, if you at least give notice of an issue, you then proceed to discovery, and if there is nothing there, then the other side is required, more or less, to request a summary judgment.
Don't you have to plead damages?
Yes, Your Honor.
Well, pleading prejudice is like pleading damages, isn't it? I mean, that's how you were, not just that I was wronged, but consequence of
Well, there is that requirement, but a statement of in excess of $20,000 is sufficient notice pleading as to what you're looking for. You don't have to give a specific. That's what trial and discovery are all about, and assessing what those damages are. And I think what we wind up doing is putting the cart before the horse. And I recognize this court in Edgar in 2012 basically found that the Court of Appeals erred by not assuming counsel was ineffective and then specifically addressing the prejudice prong. And that was a case similar to Campbell, wherein counsel had argued guilt of his client on 2 lesser counts while arguing not guilty of the main count of murder. And some of the difficulties that we have, and I think it shows up in this case, is without there being any further factual development, I don't think it's necessarily possible to assess the prejudice or the degree to which it might go. In Mr. Soto-Morales' case, and one of the issues that he had was that his attorney lied to him about who had taken the continuances.
And so,
this is kind of,
and so anytime you make that allegation, you're entitled, that's the question I have. If you raise the raise the question that there's been a lie between the client and counsel, that rises to a level of automatically getting a hearing?
I think so, Your Honor. If we look back at
any inmate in prison can say, during this process, I was lied to by my counsel. Automatic hearing.
Pretty much.
Doesn't have to result in prejudice.
It's never been overruled, but if we look at State versus Floyd and Wright, and we go back to, I believe, 1996, the standard there was that any fact that was not a part of the record, no matter how probable, would grant a right to an evidentiary hearing.
It's like failure to investigate.
Yes, Your Honor.
It's been kind of a golden key to an evidentiary hearing.
Because there's no way to assess.
On paper.
Exactly.
On
and
paper
what we're
alone.
talking about are issues that aren't included in the record, that can't be assessed by a review of the record.
Help me with this, though, because in this case, we've got a pro se motion alleging a speedy trial violation that was filed on February 21st. The state files a response on March 2nd. I mean, untangle that, because then the motion is withdrawn. The defendant never raises the question again throughout all the proceedings, and so it seems like there's something going on that a court can look at to go, wait a minute, this doesn't make sense, that we're worried about counsel lying to the guy when we went through all of this and then nothing was said after March 10th. Because, I mean, they had a hearing set on this pro se motion, and it went away, and then nothing's ever said about it. So, I mean, am I right in what I've recited? Is there some other dimension or argument you make about this, these pleadings?
Well, it's part of what we don't know. Was it withdrawn because counsel said, hey, I did take those continuances? Did he say that after the fact? But this is one of the rare instances where I think we actually have
But the
a
state's,
prior record.
and here's my problem. Doesn't the state's motion, or response, not motion, but the state's response tell everybody it's the defendant's request for all these continuances? And so I don't see how you get into my lawyer lied about it, because here's this paper record.
Well, that was actually in the motion that he filed in February. And what backs up, I think, his issue here was his motion states, and this is cited in my brief, all of the continuances in my case have been attributable to the state. Whether or not it's factual, the issue is coming from his perspective. My attorney told me that he didn't take any of these continuances, that it was the state. And at that time, he filed the motion. So, no, and
But he's on notice. But he's on notice when the state files its response that it's the other guy, and that it's his lawyer that's done this, and then nothing more is said. And we know this guy knows how to file pro se motions, so it seems like all he has to do is raise his hand again, but it's dropped. And so once it's dropped, what do we do with it?
Well, I think we have an obligation to investigate his allegation now that his counsel lied to him previously, and be able to assess whether or not there was poor communication, ill communication, no communication,
As-
and the relationship between client and attorney.
And the prejudice is he would have gone to trial in June rather than in March.
The prejudice is if we show that his attorney was lying to him about his representation of his client, then I think we get into a structural error of counsel not representing his client and being deceptive. And it's more a chronic issue and one that can only be developed by the granting of an evidentiary hearing.
One of the weirdnesses about this case is that because it has to do with speedy trial, that's really the only way you get to prejudice, right? As a logical matter, because since the state was never seeking to move the trial date off, then he just would have gone to trial quicker. And he really wouldn't have, I mean, the natural outcome here wasn't going to be a successful motion to dismiss. It was going to be, so the only way you get to prejudice is if you somehow label deception by the defense counsel as structural error.
Correct, Your Honor. And that's why
And do you
we're not
have-
arguing, so he should have been granted a speedy trial motion. I mean, we totally accept that defense counsel's actions
He just
are
would have gone to
attributable
trial
the defendant.
quicker. Yeah.
That's not our issue. But our issue is, my interpretation is, by his motion saying, prior to the state's response, all of these continuances have been taken by the state, supports his 1507 3 years later, where he says, my attorney lied to me about who had the continuances.
I guess I'm not hearing you really respond to what I think is Justice Biles' question, which is, why aren't you really just taking this a step further? You're not just saying, my attorney lied to me, but I'm not even going to be responsible for what's in black and white in the pleadings, which is, my attorney requested these continuances. We're not even going to assume that the defendant has to be responsible for the information that's in the pleadings. Are we going to assume he didn't have notice of what was in the pleadings? Does that make sense? The pleadings verify that the state said it was this defense counsel and defendant that asked for the continuances. Why is that a lack of communication or ill communication problem, and why isn't it he received communication?
Well,
Why do we need to go any further than that?
Because his allegation is his attorney lied to him and told him the state has taken these continuances. Then he proceeds to file his pro se motion based upon that information, and then he's told by the state,
I
"Oh, it was
understand his
actually your
allegation.
counsel."
I'm just saying, so in every case now we're taking it a step further is what I'm saying. Not just my attorney lied to me, but then I could read it in black and white. It's in my pleading that my attorney requested this, and I'm still going to wait 3 years to do something about it.
Well, he couldn't bring it up on direct appeal because there wasn't a record made of it. And also, as you all well know, absent a Van Cleve hearing or a hearing for ineffective assistance of counsel at the time of sentencing or prior to, it's not appropriate for an ineffective assistance of counsel claim.
Let me go at it from a different way.
Yes, Your Honor.
At the time the state filed its response saying it was defense counsel's continuance motions, why was that too late for your client to do whatever he may have wanted to do? Why was that too late at that point? His attorney lied to him, and so he didn't know, but he found out when he filed his motion. The response came and said, no, it wasn't the state's, it was yours.
That's what made a liar out of his lawyer.
That's what made a liar out of his lawyer. Why was that knowledge why did it come too late at that point for him to obtain the relief? For instance, motion for substitute counsel, whatever. Why was that information too late at that point for him to obtain the relief that he could have gotten?
I don't think it's too late at that point, and that is a possibility. But that's neither here nor there. There's not a time limit on his being able to file this motion now. And it's thoroughly appropriate for it to be
Well,
handled
it
as an
has to do
ineffective
with prejudice. It has to do with, there has to be some prejudice to the defendant from the action of his attorney. And that's what we're trying to get to. That's what the Court of Appeals said. There was no harm, no foul. And what I'm trying to ask you, why was there harm at the point that he did find out about the lie? Why was that harmful at that point? What did it preclude him from doing?
Well, I think it may well have precluded him from trusting his counsel.
Well, that was my point earlier with my question. You have to
Okay.
rely on inherent prejudice, structural error, in order to get to prejudice, because you don't have other prejudice here.
Correct.
I mean,
But-
you can see from the papers here, it's a weird thing about this case. Most of the time when a client shows up and says, my lawyer lied to me, people are going to take a pretty hard look at that. But here, what the lie was supposed to be about, he learned of it at a time when he could have done something to help himself, and he did nothing, as my two colleagues on the ends of the bench have pointed out. So it has to have been some sort of structural error to get to prejudice. And what's your support that that's structural error?
And this is my point exactly. We need an evidentiary hearing.
But what's your
No, we
legal
need to
flesh
support?
this out.
What's your legal support? Let's assume all that happened, which, I mean, we're just going to assume it for purposes of argument
An
today.
individual has a right to conflict-free counsel. And I think a conflict is automatically created if an attorney is lying to his client.
Okay. But it's
The
structural
prejudice is an
error?
inability to trust, and I think that it then can be potentially a need to look at whether this was something that was pervasive throughout.
But wait, I just am trying to get to this. Let's assume there was lying. Let's assume there was a breakdown, there was a conflict. Let's assume all of that. What's the support that that's structural error that would satisfy the prejudice prong of Strickland? That's my question. Do we have authority that says that's structural error that would satisfy the prejudice prong of Strickland?
I don't know of any specific authority on that, but
Okay.
I believe the right to counsel, conflict-free,
But we have-
and who is an advocate and who is a representative of his
We
client.
always employ the prejudice prong on ineffective assistance, no matter what the source of the ineffective assistance is. We always apply that prejudice prong anyway, and that's the piece I'm trying to get to. And I think what you've told me is you don't have authority for structural error on the prejudice prong.
Not that I can say directly,
Okay.
Your Honor.
Thank you.
Thank you.
Any further questions of counsel? You're out of time. Would you like 30 seconds to wrap up? Understanding you've reserved time for rebuttal.
Yeah, very good. The only other thing that I would say is the burden that we're putting on these individuals is to prove and plead their case in their initial document. The document's not set up to allow them to do that. They aren't set up to do that because they don't have counsel or assistance. And generally, by the time counsel does get assigned, they're past their 1 year, and there's no way to amend or improve or make any changes unless it specifically relates to something they put in the draft.
So at a minimum, you'd like to see an amendment in the form.
I believe it's necessary, and or actually, I think at a minimum, I think the court needs to take that into account and adapt how we are applying the standards of review and the law against them. I think the form definitely needs to be changed, but we can't do that as it would apply in this case.
Okay, thank you.
Thank you.
Thank you.
May it please the court, Assistant District Attorney Boyd Ishwin on behalf of the state of Kansas. I'd like to address Mr. Whalen's big picture argument first. And as he cites in his brief on page 10, or at least his petition for review, I think is the first place you find it, on page 10 through 11, the case law does indicate that where a 60-1507 motion alleges facts which do not appear in the original record and which, if true, would entitle plaintiff to relief, then the hearing. And I think that's what Mr. Whalen is skipping over. And that's what the Court of Appeals cued on, and that's what the district court cued on. As it was framed to those folks, and myself, at least additionally, the issue was a speedy trial violation. Well, if it's true, you could have a hearing. Well, they skipped to the prejudice prong and found, well, even if the allegation is true, that the attorney took the continuances, then there would be no prejudice here. That argument has been furthered with my supplemental brief indicating that the movement was being held on more than one case. So there's no speedy trial issue. Mr. Whalen, I'm sorry.
But speedy trial, the whole concept presumes that there is prejudice to a person who's not brought to trial in a timely manner. Wouldn't you agree with that? We've indicated that you have a right to speedy trial because there's prejudice to the defendant if they don't get a speedy trial.
If you don't receive a speedy trial, you've been prejudiced. That's
And
true.
if a person wanted a speedy trial and their attorney was lying to that person about who was taking the continuances, that precludes them obtaining a counsel that will get them the speedy trial. Why
Absolutely.
isn't that prejudice?
Well, that is not correct in this case because this man was being held on more than one case. So there is no speedy trial, statutory speedy trial issue. And as the Court of Appeals,
was that in the record?
it is in the record. Yes.
Okay.
And as
That he was being held on multiple.
That's correct.
Okay.
yeah,
Thanks.
at least
And-
in the pleadings,
I don't recall that. Was that the basis of the Court of Appeals?
that was not the basis of the Court of Appeals.
What we
opinion.
have is, we have a review, so you're saying the Court of Appeals was right for the wrong reason?
Well, it's really confusing because this issue depends on what Mr. Whalen's raising, and I understand Mr. Whalen to not be raising an issue of speedy trial. He's just raising an issue that his attorney lied to him.
Well,
And
well, and that's
somehow
what
that-
I'm getting at is the Court of Appeals, as I read it, said, well, it doesn't matter if he lied because there wasn't any prejudice. You know, he would have just got a trial earlier. Well, the fact that he could have gotten a trial earlier is a benefit if we presume that the reason we have a speedy trial statute is because it prejudices inmates who don't get a speedy trial. And if an inmate doesn't know that they're waiving their speedy trial through their counsel's continuances, that's prejudicial. And so there may be other reasons, that it doesn't apply in this case, but that's what I had trouble with, is just lying about who's taking the continuances is no harm, no foul. It's not prejudicial to the client.
Well, and again, I think there's confusion. I don't think that's what the Court of Appeals ruling indicated. I think the Court of Appeals took this issue as a speedy trial issue. And the Court of Appeals indicated, well, look, you're bound by your attorney's decisions. The attorney's decision was to continue the cases. Therefore, at those times do not attribute to the state. And we have no speedy trial issue. There's no prejudice because that time doesn't go to the state. State's not beyond their time. As I indicate, I'm sorry, Your Honor.
No, you continue.
As I indicate, the confusion here is that we need to determine whether this man is actually claiming a speedy trial issue or if he's just claiming, which I think I'm hearing, that my attorney lied to me. So therefore, I need to have a hearing about whether he lied to me. And the frustration I think that this court is saddled with is, why are we having a hearing just to see if an attorney lied to you on an issue that we know you can't win on because you're not being held solely on account of this single case? Why would we have a hearing on that? And I think that's rolled up in the actual terms of the case law that indicates that you would be entitled to a hearing if the claim would be successful. And we know this claim cannot be successful. And I don't know that the word is caution, but I'm not very articulate, so I'll just use the word caution. I would caution the court from issuing an opinion that indicates that now we're going to have hearings on 1507s to see if trial counsel lied. I think there needs to
About
be
not making a losing argument.
Well,
That's what the problem
I
is
just in
here.
general, I guess, especially in that scenario. I mean, there needs to be an issue articulated that you can become successful on before we would have a hearing. And I understand my association with these types of cases, the 1507s, is going on about 13, 14 years now. I understand that it's my understanding that these cases are not criminal. They are not civil. They're quasi-civil. They're not the same as a simple civil case because we've already had a ruling in the criminal case indicating that this person has been guilty of whatever it is they've been charged with. It's not the same. It doesn't present the same in a number of cases.
They're a unique animal. Mr. Isherwood, are you aware of any authority to support your opponent's position that lying to your client is structural error?
As I stand here today, I am specifically unaware of any cases going either way, because this issue would have had to have been feathered out by reading in between the lines to know exactly what it was that was being claimed. And so now I'm at the podium for the first time with this issue crystallized, so no. But I do know that in a general sense, the court has required prejudice unless it is, I can't even remember the name of the cases where you found.
I think we know which ones you're talking
Yeah,
about.
but in a general sense, yes, you've required
Complete
prejudice.
forfeiture of a proceeding.
That's correct. I'm sorry.
My recollection has been there are basically two different types of cases when you're talking about an IAC claim. One is Strickland, when you get into, per the Supreme Court, prejudice. A reasonable probability the jury would have arrived at a different result absent the deficient performance. And then related to that, but not contained in the same vessel, is the conflict that a counsel may have. But I think even in those cases where we've said, yes, you're entitled to conflict-free counsel, we haven't necessarily said you have to show prejudice, but you have to show some impact on performance.
In other words, there has to be a conflict at least.
There has to be a conflict, and there could be one here, I guess, on its face if there's an allegation of arguing. But even if you go through all that, assume all that to be true, I think the case law has said there still has to be some impact on performance. It cannot exist in a vacuum, and so
That I believe that to be absolutely correct, and that's why, again, I use the poor word caution. That's why I caution the court in having hearings at the district court level on issues in a vacuum. But I think that exact question or comment, Your Honor, is what some of the concern was, because we already know that he was aware in this case of the attorney taking the continuances, and then he does nothing. I mean, this person, the response that I point to in our supplemental brief is a response to a pro se motion. So this particular person can't claim, well, geez, I don't know how to avail myself of the courts, so I don't know what to do. Yeah, you do. You filed this pro se motion before. You can file another pro se motion if you think there's a conflict.
And the response was served on him personally.
I'm sorry?
The response was served on him personally?
I was looking at that. The one motion that I'm aware of, the response to the motion indicates that the certificate of service indicates it went to the attorney.
Counsel.
We would be prohibited from, my understanding would be we would be prohibited from directly making contact with a represented person.
this other charge that you've said he was being held under, you've said is in the record. Do you happen to have the record site for our ratification?
I would, Your Honor. It is in our supplemental brief, which I should have. I apologize.
I have it here. I'll look for it if you want.
I'm almost there. That I lied. Well, Your Honor, it is in our supplemental brief. Looks like record volume 2, page 50 through 52. Or perhaps record volume 1, 60 through 63.
What page of your supplemental brief is that?
I'm sorry?
What page of your supplemental brief are you referring to?
6.
Thank you.
And what it should be reflecting is a response to a pro se motion. In that response, the state's attorney indicates the procedural history of the case.
I have a question, just backing up a little bit here on how this predicament happened in the first place. Is it a common practice, an unusual practice, to allow counsel to waive speedy trial without his client's consent? I mean, I know the practice when I was doing it demanded defendant's presence and either acknowledgement on the record, and I think our waiver form even include a signature line for the defendant. Do you know? I mean, I'm just curious what the practice is.
I wouldn't be able to.
I found it kind of strange that this was happening.
I wouldn't be able to speak to the practice, being in the appellate division, not being present for the continuances. I wouldn't know exactly what happens on a continual basis.
It's an important consideration. The time is basically you're waiving a right. The time is attributable to you, and I remember making plenty of explanation about that whenever a speedy trial right was waived. I'm just curious.
And I can certainly understand that, but since we don't find ourselves at those in that particular time, we don't find ourselves.
I just didn't know what the kind of common practice, if it is.
I wouldn't be able to speak to that, and I also wouldn't be able to speak to whether since this time whether it's changed with respect to some of those court's opinions that are expressed in the Court of Appeals, indicating that if the defendant objects, somehow that overrules or overrides the attorney's continuance.
Right. Yeah. It's certainly a consideration anyway.
Right. And I also, not to confuse, I'm getting short on time, but not to confuse the matter, we also make an argument in our supplemental brief with respect to the new statutory provision indicating that once, more or less indicating that once a continuance has been attributed to the defendant or defense counsel or the defense side, it cannot be assessed to the state after the fact,
right,
unless there's a showing of prosecutorial misconduct and I think something else that doesn't apply. I can't recall. But that's important because, the state's making, I completely understand the statutory right to a speedy trial. I get it. I know it's important, but we also have to have something that's workable. And when the state finds itself in a position of having to try so many cases or getting so many cases ready for trial, and there's one case that needs to go quicker than this one, and they see that, well, this one only has so much time left, I'm going to have to make a decision, how much time have I taken? And they take a little bit more time, which doesn't run afoul of the statutory speedy trial right, only to find out that they're going to put more time back on them after the man's been tried and convicted. The years later on a 1507, this is not workable. There has to be a workable resolution to this as well. But unless the court has any questions in this particular case, we do feel that the district court and the Court of Appeals, perhaps not always for the right reason, but did get the ruling correct, and that on the issues, the actual issues presented, that there is no need for a hearing because it's not possible to show prejudice.
Any more questions of counsel? Any further presentation?
No.
Thank you, counsel.
Thank you.
Nevertheless, if we adhere to the tack we took in Galaviz, we would apply the adverse effect test, notwithstanding that this case involves successive representation, because the, quote, state does not argue any other test should be applied. 296 can at 192. To clarify again, that test is less stringent than the Strickland test. And as we said in Boldridge, a defendant claiming that his or her attorney had a conflict of interest that affected the adequacy of counsel's representation need not demonstrate prejudice in the traditional sense, i.e. need not establish that the error affected the outcome of the proceeding. And that's from this court's decision in State versus Stovall, 312 P. 3rd 1271, and that was from just this past November 2013.
That gets back to the point we were discussing with opposing counsel earlier, that does not suggest structural error. That suggests there has to be some adverse effect or impact.
I agree.
And so what do we have here?
Well, I think that's part of why we need an evidentiary hearing as to whether or not this had an adverse impact. I think, and I'm still coming from the fact I can't believe that an attorney would lie to his client about something as, almost innocuous as continuances. But I don't see how a misrepresentation is going to aid or let the defendant feel free to assist in his own defense because he can't trust his attorney.
But we know the defendant was willing to go ahead and go to trial and without raising this as any kind of a point of conflict or
Your Honor,
stress.
we don't know that. That is
Sure we do.
speculation. And that's the whole problem. This is all speculative. I honestly don't understand why a hearing is so abhorrent in these cases when we do not have facts in the record to support the issue. That's why an evidentiary hearing is necessary. Because we don't know that, Your Honor. We know he went to trial with that counsel. Do we know why he didn't fire his counsel? No. Do we know whether or not he had any further problems interacting with counsel after he discovered this lie? No, we don't. And so we can't make that assumption. We can't make the assumptions about what is going on. And I think we have the same issue with the Court of Appeals finding as it related to the jury instruction. The Court of Appeals says, well, the jury never got to the involuntary instruction because they found voluntary manslaughter. Well, no, we don't know that. If 5 of the jurors thought that he should get involuntary manslaughter and 7 of the jurors thought that he should get second-degree conviction, there's consideration of the involuntary. It doesn't just stop that they read the paragraph and go to the next. And the absence of his counsel failing to request what this court has required as an ancillary instruction, shows ineffective assistance of counsel for not understanding the law, denied Mr. Sola-Morales the ability to have a second theory of the defense presented, which matched at least one of his stories. And I grant you, this was not great facts that Mr. Sola-Morales produced for himself, but he got the self-defense instruction. And the involuntary reckless was applicable and could have been, but his counsel said, no, we don't need it. The Court of Appeals' assumption is that the jury just never got there, but we can't assume that that's what's going on inside of the jury room. And to answer your question, Justice Rosen, regarding in Sedgwick County, if you want a continuance of trial, you send an email to the criminal assignment judge's clerk before Thursday, and you get a continuance. Clients are never discussed. Clients are never brought into court. There are no signatures, no waivers. The court basically never knows how the person's doing on speedy
I
trial.
understand, maybe I missed it, on felony cases, that's the case?
Yes, Your Honor. And as long as it's by agreement with the prosecutor, the continuance is granted. I don't know, but I can't speak to other counties. But that Sedgwick County, it's mostly by email. And nobody is ever apprised of anybody's time and how much time is running. And I'm sure I am close to time
The
myself.
defendant is never given the formal waiver? A defendant never comes in to make a formal waiver of speedy trial?
No, Your Honor.
Any further presentation? You're out of time.
Not for myself, Your Honors. Thank you so much.
Any questions of counsel? I see none. Thank you. Thank you both for the arguments this morning. Court will take this matter under advisement.